Good day, my name is Martin Engelbrecht. I'm a legal advisor from the CSGO Elsje-Marie office, specializing in the Consumer Protection Act and the POPI Act.
Good day, my name is Elsje-Marie van Zyl. I'm also a legal advisor at CSR Elsje-Marie, also in protection of personal information and the Consumer Protection Act.
Elsje, today we're going to discuss how the Consumer Goods and Services Ombudsman is relevant to clients' businesses.
Martin, can you please just tell me what is an ombudsman?
Yes, Elsje, an ombudsman is an independent, impartial person with the authority and the responsibility to receive and investigate and formally address complaints. The Consumer Protection Act has authorized these ombudsmen in terms of Section 82 of the Consumer Protection Act. And there are certain ombudsmen that have already been called into life, such as the Motor Industry Ombudsman of South Africa, or MIOSA, and the Consumer Goods and Services Ombudsman, or CGSO, which we will be discussing this today.
Martin, can you also tell me what is a supply chain in the setting with the ombudsman?
So a supply chain, as defined in the Consumer Protection Act, means the collective of suppliers who directly or indirectly contribute to the ultimate supply of the good or service to the client. Now, how that becomes applicable is the CGSO, which is often referred to as the Mega Ombudsman, is mandatory to all participants in that supply chain that provides or markets or offers to supply goods or services to consumers. The CGSO also has their own rules contained within that code, and in terms of Clause 4 of the code, it applies to all participants unless their industry is regulated elsewhere by public regulation, by another code prescribed in terms of Section 82 of the Consumer Protection Act, or where a complaint falls within the jurisdiction of another industry ombudsman.
Are there any exceptions to this?
Yes, there are a couple of exceptions. The first one is where the transaction is not covered by the Consumer Protection Act. So, for example, if the person who has the complaint does not fall under the definition of a consumer, so is a, let's say, business with an annual turnover or asset value of over 2 million, if the public regulation has already governed another ombudsman, such as the motor industry, which I've mentioned, any communication electronically serviced, meaning under the Electronic Communications Act. So if you buy from Takealot, that is governed by that and not by the CGSO. Any transactions from the organs of state, so whether it be municipal, provincial, or national organs of state, and then financial institutions do also have their own regulations and complaints, policies and procedures.
But what does this mean for our clients' businesses? How will this affect them?
Participation with the CGSO is mandatory, meaning you have to register and comply with their rules. All participants or businesses must also contribute to the funding of the operations of the CGSO. This is done by a joining fee and then an annual levy, with the possibility of special levies being levied by the CGSO. These levies are determined by the board of the CGSO from time to time. The fees payable is also available on their website. Non-participation with regards to registration and payment of this is, technically speaking, against Section 82 of the Consumer Protection Act. So there is a risk of compliance orders being raised against your business, either by the National Consumer Commission, who will do the investigation and then referred to the National Consumer Tribunal. The contravention of these rules, non-payment, non-registration, also has the possibility of a financial implication, in the sense that the National Consumer Tribunal may levy an administrative fine up to 10% of your annual turnover.
So what does a business have to do after registration?
The code of the CGSO requires participants to carry out the following responsibilities. Firstly, they need to establish an effective internal complaints handling process, or in other words, a complaints policy. They need to monitor this complaints policy and ensure that it is effective. They need to display prominently at all their trading premises the CGSO decal or logo. They need to ensure that a copy of the code or a summary of the internal complaints policy is made available to any consumer upon request of that. And they need to make sure that the staff or designated agents in their business have the adequate knowledge of the Consumer Protection Act, the regulations, the CGSO code, and their internal complaints policy. They also need to ensure, where it's possible, to keep proper records for a minimum of 3 years of the complaints that are received, with some details to be able to identify that complaint or claim. They also obviously need to cooperate with any reasonable request from the CGSO in a timely manner. Failure to cooperate will also be taken into consideration when the matter is referred to the National Consumer Commission and to the National Consumer Tribunal, which might have an effect on the compliance notice and the severity of the administrative fine.
So when businesses receive complaints, how must they handle that?
In terms of the CGSO, there are two separate complaints that can be done. There's an internal complaint. That's where a client or consumer comes to the business and has a complaint that they want to lodge in terms of their internal complaint policy. That should be dealt with internally as far as possible. Should the complaint be sent to the CGSO, the CGSO will then send a formal letter setting out the complaint by the consumer, details of the consumer and any documentation that might go along with that, till slips, anything like that. The business has then 15 business days to either settle the complaint or in writing set out the reasons why the complaint was not settled and why the dispute has arisen to the CGSO. The CGSO encourages businesses to take these 15 days to try to resolve any dispute that there might be. But should the matter then not be resolved after the 15 days, that letter that I mentioned that you set out, the reasons for not settling the matter. You have to be incredibly careful what you put in that letter. I strongly advise that you do not compile and send that letter without the assistance of your CSR consumer protection representative. The complaint then not settled, the CGSO having received the formal letter from the business will then make a merit evaluation on that. There's a possibility that the entire matter could then be referred to the National Consumer Commission for investigation. After investigation, they may refer it to the National Consumer Tribunal, and they are the tribunal who may issue those administrative fines that I spoke about earlier.
Thank you, Martin. I now understand that clients need to be registered with the Ombud and also the procedure that needs to be followed. But what can our clients do when confronted with these matters that they don't maybe know how to handle themselves?
Well, the easiest option if you're confronted with anything with regards to an ombudsman, the CGSO, or the National Consumer Commission or Tribunal is to contact your nearest CSO office for assistance.
Thank you, everyone. That's all we have time for today.